Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that from time to time we try to bring for you different subjects, and under those subjects we try to give you the essential information, the essential topics through which it becomes easier for you to study your course material. Dear friends, as you know that in some of the previous sessions we talked about the President of India. We would be continuing further and we would be discussing about the ordinance making power of the president, as well as we would be discussing about the governor, the positions and the power of the governor in this very session of ours today. And for this we have again with us in our studios Dr. Rakesh Kumar. Dr. Rakesh Kumar is assistant professor in University School of Law and Legal Studies, Guru Gobind Singh IP University. So dear friends, let's take advantages from his experiences and try to understand first about the ordinance making power of the president, and then afterwards we would be discussing about the governor. So hello sir, welcome to the EduSet lecture. Once again, as we have already discussed about the president, but this portion was left, so we would be discussing with the ordinance first. So over to you sir.
Thank you Deepika. Good morning listeners. On my previous lectures on the president, I have given you the detailed analysis regarding how the president of India is being appointed and what kind of the power is being conferred on the president under the Indian constitution. In my previous lectures, I was not able to cover the ordinance making power of the president because of the paucity of time. So I utilized this time to give you some idea about under what circumstances the ordinance can be issued by the president, and what are the limitations by which the ordinance making power of the president will be regulated. If you see the constitutional scheme, then under Article 123 clause 1 of the Indian constitution, the president has been given power to issue the ordinance, and the power of president to issue ordinance come broadly under the legislative power of the president. So if you see the verbatim of this provision, say that if any time when the both house of parliament are not in sessions, then the president is satisfied that the circumstances exist which render it necessary for him to take immediate actions, he may issue ordinance as the circumstances appear to him required. So if you see the clause 2 to Article 123 says the ordinance issued by the president shall have the same force as the act of the parliament. So as far as this ordinance which was issued by the president under Article 123 is concerned, if any such ordinance has been issued by the president when both house of parliament are not in sessions, then such case what is being further prescribed that if any such ordinance is issued, then it has to be laid before the both house of parliament, and it shall cease to exist at the expiry of 6 weeks from the date of the assembly of the house. So within 6 weeks from the assembly of the parliament, here the ordinance which has been issued by the parliament, either it has to be approved or disapproved by the act of the parliament. If the parliament had decided not to take any action with respect to any of the such ordinance which was issued by the president when the parliament was not in sessions, then after the expiry of the 6 weeks, it will automatically cease to exist. So as far the ordinance making power of the president is concerned, here this power is subject to the certain limitations, and if you see the limitation which is being prescribed, that the first condition which has to be fulfilled regarding the issuance of ordinance by the president is that it must be promulgated at the time when both house of parliament are not in session. So as far the session of the house is concerned, it comes to an end on the prorogations or dissolutions of the house. And second requirement that if the one house is sitting, then there is a no bar regarding the issuance of ordinance. It means ordinance can be issued when only one house in the sessions, because the law cannot be passed by one house alone. So because if you see under our parliamentary system, then we have the both house, we have the one house that is the Lok Sabha, and other house that is the Council of State, that is the Raj Sabha. So if the Lok Sabha is being dissolved, and if at that point of time it appears to the president that the ordinance has to be issued with respect to certain matters, then that case here the mere existence of Raj Sabha will not be act as a limitations for the president to issue the ordinance, because at that point of time they can issue the ordinance, but as far the approval of ordinance is concerned, for that purpose the consent or assent of both house of parliament is required. The third requirement that the President must satisfy the circumstances exist which render it necessary for him to take immediate actions. So, as far the satisfaction of the President is concerned, here the court cannot inquire into the subjective satisfaction of the President, because the existence of the necessity for the promulgation of ordinance is not a justiciable. The validity of the ordinance cannot be tested on the grounds similar to those on which the other executive or judicial action is tested. So, the motive, propriety, expediency as well as the necessity of the legislative act are the for the determinations of the legislative authority, and it is not for the determinations of the court. So, it cannot be challenged on the ground that it is a case of the non applications of mind. So, it is for the President to decide. As for the President power to issue ordinance is concerned, definitely President will not act on his sole discretions. Here the President is required to act on the advice of the Council of Ministers headed by the Prime Minister. So, if the Council of Ministers has requested the President to issue the ordinance, then it depends upon the subjective satisfactions of the Council of Ministers, and expediency, propriety, this is something which the legislature has to decide. It cannot be decided by the court by simply saying that the before issuance of ordinance either there was no necessity for the issuance of ordinance, or it is a case of the non applications of mind. Apart from this, the other limitation which is prescribed with respect to the issuance of ordinance is that the each ordinance made by the President during the recess of the Parliament must be laid before the both house, and it cease to operate at the expiry of the 6th week from the re-assembly of the Parliament. And if before the expiry of those date of the 6th week, if it is disapproved by the resolutions of the both house, then it will cease to operate. And if the both house of Parliament are summoned to assemble on different date, then this period of 6 week has to be counted from the date which are later of the assembly. So, if the suppose the Rajya Sabha has been summoned on particular date, and subsequent to that if the Lok Sabha is being summoned, then that case this 6 week duration has to be counted from the date of the assembly of the second house. And if the ordinance is allowed to lapse without being placed before the Parliament, then it cannot be treated as void ab initio, and if any actions taken by the executive under the force of the such ordinance, then it will be continue to be valid. So, as far the ordinance making power of the President is concerned, here you have to also keep in mind the certain verbatim certain words which has been used by the constitutions maker under Article 123 clause 1 of the Constitution. The most important word which has been used is the satisfaction of the President. So, as far the Article 123 is concerned, it speak of the satisfaction of the President who in turn is required to act on the aid and advice of the Council of Ministers. So, court cannot inquire into the reason for the subjective satisfaction of the President or into the sufficiency of those reasons. So, existence of the necessity for the promulgations of ordinance is not justiciable, and it cannot be tested on the other grounds similar to those on which the executives or other action are being tested. And if you see the approach of the judiciary with respect to the issuance of ordinance under Article 123 is concerns, in Venkata Reddy versus State of Andhra Pradesh case way back in year 1985, the Supreme Court said that since the ordinance making power of the President under Article 123 and the Governor under Article 213 are the legislative characters. So, just like the legislative characters, so it is just like the legislative power of the President. So, its exercise cannot be questioned on the ground of motive or non-applications of mind, or on the ground of its propriety, expediency as well as the necessity. And further, in the Samsher Singh versus State of Punjab, it's a very landmark decision the Supreme Court decided way back in 1974, where the Supreme Court stated that the ordinance is promulgated in the name of the President and in the constitutional sense on his satisfaction. However, in the truth, it is the promulgated on the advice of the Council of Ministers and their satisfaction. So, President has no discretionary power with respect to the issuance of ordinance, and he has to act only on the advice as and when tendered by the Council of Ministers. So, on the basis of the advice of the Council of Ministers, the President will have the power to issue the ordinance as requested by the Council of Ministers. And as far the legality of the ordinance is concerned, it is having the same force as the act of parliament. So, the power to issue ordinance is the legislative power of the president, and it is devised to meet the urgent situations and necessity, which is something which is very mandate or necessary for the ensuring the good governance as well as the peace in the working of the executive branch of the government. Because if the certain matters where the urgency required, and that in that case it will be for the executive decide as to whether, because if the with respect to taking care of those matters, there is a no existing provisions of law, and if it appears to the council of ministers that with respect to that matter the certain law has to be enacted. And if you see the procedures of making law under the Indian scheme is concerned, here it is a very cumbersome process, because for this purpose the bill has to be introduced in the house, and then afterward it was subject to the debate, and if the member requests, then it may also be referred to the various committee, select committee or standing committee for the review of the proposal for the such bill. And once it has been debated and passed by the one house, then it has to be transferred to other house, then again it is subject to the same procedures of the debate, and it is only after the passing of the such bill by the both house of parliament, then it will be sent to the president for his assent, and it is only after the assent of the president it will become an act. So, in emergency situations when both house of parliament is not in sessions, and if it appears to the executive that with respect to the certain matter the certain immediate action is required, and there is no existing legislative provisions to take care of the such contingency, then definitely in that case here the executives can take a route of the ordinance to tackle the such kind of the situations. As far the power of president to issue ordinance is concerned, it was also being challenged in the A.K. Roy case, where the constitutionality of the national security ordinance was being challenged, and the Supreme Court has in that case upheld the ordinance which was issued by the president to under the national security ordinance, which was later on replaced by the National Security Act, which was enacted by the parliament. So, as far as the constitutionality of the national security ordinance is concerned, here in the A.K. Roy case, the Supreme Court by majority of 4:1 held that the national security ordinance was valid and not violative of the Article 14 of the Constitution, and it stands on the same footing as the law passed by the legislature. However, the majority has pointed out that the ordinance would be subject to the test of the vagueness, arbitrariness, reasonableness as well the public interest, and it has to be passed only when the parliament are not in sessions. So, as far the power of president to issue ordinance is concerned, it is definitely subject to the same limitation as is applicable with respect to the law making power of the parliament. So, with respect to certain matter, if the parliament is not having the competencies to make a law, and if that subject has been assigned to the state government, then definitely in that case without the specific request of the state, here the parliament will not have the power to make a law. So, as far the ordinance making power the president is concerned, here the president can exercise this legislative power on the advice of the council of ministers, provided the subject pertaining to that ordinance is mentioned either in the union list or in the concurrence list, or if the two or more state has requested the parliament to enact law with respect to the such subject matter which belongs to the state list. So, if any such law is being enacted by the parliament on the request of this state legislation, then in that case such law can also be adopted by the other state under the Indian constitutional scheme. And as far the limitation is concerned, here this issue was also being considered by the Supreme Court in R.K. Garg versus Union of India case way back in year 1981, and here the 5-judge bench of the Supreme Court by majority of 4:1 held that the special bearer bond immunity and exemptions ordinance 1981 was not ultra vires to the Article 123 of the Constitution. So, president is competent to exercise his power of ordinance making, modifying, altering the tax law. So, with respect to the tax law also, so mostly whenever the ordinance is being issued, either it pertains to the financial matter or it is something which may pertains to the safety and security of the state. And as far the limitation which is prescribed that within 6 weeks of the assembly of the parliament, it has to be placed before the both house of the parliament, and it has to be either approved or disapproved by the parliament. But if you see the practice which was being adopted by the some of the state government with respect to the governor power to issue ordinance is concerned, here the DC Bathwa case is very important, where the entire ordinance making power of the president as well the governor was being strictly scrutinized by the Supreme Court, and it was brought to the knowledge of the Supreme Court that here the state of Bihar has issued the more than 256 ordinance between 1960 to 80s, and in the various cases that it was promulgated or re-promulgated, and some of the case it was re-promulgated with the assent of the president also. So here this fact was brought in knowledge that the ordinance was being issued and it was being re-promulgated from time to time without seeking the approval of the state legislative assembly. So when this fact was brought to the knowledge of the court, then the court has said that this is something which can be called a fraud with the constitutions, because here the ordinance making power has been devised only to take care of the extraordinary situations, and it cannot be used as a means or instrument to bypass the legislative system, where the parliament has been given power to make a law with respect to any of the subject which has been assigned the 7th schedule of the constitution. So this kind of fraud cannot be practiced by the elected government by simply bypassing the assembly or the parliament, and they can take the route of the ordinance to take care of the particular situations. And as for the one more thing which you have to keep in mind with respect to the ordinance, that if any ordinance has been issued, and if any actions or decisions which has been taken by the government under the force of that ordinance, then it will continue to be valid despite the fact that such ordinance was not being approved by the parliament or state legislative assembly. And if there the two house in the state legislature, then by the both house of the state legislature, then that case it will cease to exist, but whatever the decision has been taken during the force of the ordinance, it will continue to be valid. So this is the power which has been given to the president to take care of the extraordinary situations which may arise with respect to the any matters which the executive is required to take the immediate and prompt actions. So after discussing the ordinance, almost I have covered each and every aspect of the power and positions of the president. Now I am coming to the other important aspect of the Indian constitution, that is the governors, their appointment, their power, and all the controversies surrounding the office of the governor. So as far the governor is concerned, here if you see the part 6 of the Indian constitutions, it describes the structure of the government in the state, specifying the first schedule of the constitutions. So as far the governor is concerned, here the article 153 create the office of the governor, and it says that each state shall have the governor. However, one person can be appointed as a governor by governor for the 2 or more states. So as far the governor is concerned, here each state shall have the governor, but the same persons can be given the charge of the 1 or more state, and he can serve as a governor if the governor is not being appointed with respect to that particular state. As far the power president regarding appointment of governor is concerned, this issue was intensively debated during the Constituent Assembly debate, and during the Constituent Assembly debate, the makers of the Constituent Assembly was having the two options. One option was either to have the governor elected by the entire state, or have the governor as the central government nominee. But the constitution's maker has not opted for the system of the of the elections of the governor by the electorate of that particular state, because in that case it was being the apprehension was being expressed by some of the members of the Constituent Assembly that there will be a conflict and the clash of the personality between the office of the governor as well as the office of the chief minister, because in that case if we opt for the system of the elections of the governor as it is being practiced in the USA, then that case what will happen that here the governors will claim that since he is being elected from the electorate of the entire state, so he will have the pre-eminence over the power of the chief minister, because the chief minister is only elected from a particular constituencies, and he is being elected as the leader of that political party to be appointed as a chief ministers by the governor. So the constitution maker, instead of opting for the USA system of the elections of the governor, they have opted for the Canadian system of the appointment of the governors by the central government. And if you see the argument which was being advanced, that the fourth set of argument was being advanced to justify that instead of having the elected governor, we will have the system of the governor as a nominee of the central government to be appointed by the president. So as for if you see the constitutional debate, then the fourth set of argument was being advanced to have the governor as the nominee of central government. The first was that it would encourage the centripetal tendency and thus promote all India unity. The second argument was that in parliamentary system, the head should be impartial, but if we opt for the system of the governor as a elected representative of the state, then definitely in that case he has to be party man. And third, the conflict may arise between the office of the governor and the chief minister. For the former might claim to arrogate the power on the plea that he is being elected by the whole state as against the chief minister, who would be elected only from the one constituencies. And fourth, the governor being a mere figurehead, so spending money for his elections would be a sheer wastage of money. So instead of opting for the system of the governor as to be elected by the state, we have opted the system where the governor has to be nominee of the central government to be appointed by the president, and he shall hold the office during the pleasures of the president. So because under the position of the governor is similar to the president, and except the certain matters, here the president is also required to act on the aid and advice of the council of ministers. So as far the governor is concerned, with respect to the certain matter where the governor is supposed to exercise his discretionary power, here the governor is also required to act merely on the aid and advice of the council of ministers. So council of ministers headed by the chief minister. So whatever the advice which will be given by the chief ministers headed by taking the view of the cabinet, then that case the governor has to merely act on the advice of the council, and this is the essence of the parliamentary form of the government. Under the parliamentary form of the government, here he is merely act as a check, he is merely act as an advisor, he is merely exercise his wisdom to exercise the governor, and if with respect to a certain matter, if any decision has been taken by the council of ministers, and if the governor is having any reservation with respect to that matter, then that case they may simply ask the governor, simply ask the chief ministers to get the matter to be reconsidered by the cabinet. So as far the positions the governor is concerned, he is having the dual capacity. So he is the head of the state as well as he is the representative of the center in the state. So he works as a channel of communications and contact between the center and state. And it is also felt that with the view to ensure the smooth functioning of the constitutional mechanism of the state, it would be best to consult the chief ministers while appointing the governor, and convention has accordingly grown where the chief minister, the governor was is being appointed by the president after consulting with the respective state chief ministers. However, if you see the practice which has developed in the working of the Indian constitutional scheme, that after the fourth general elections, when the complexions of the complex of the state has changed, and because what was happening before the fourth general election was that the center and state was invariably being ruled by the same political party. So if it was being ruled by the same political party, then that case there was not having any difficulty with respect to appointment of the governor. But after the fourth general elections, what happened that the complexions of the political system in the India had changed, and it was possible that the center may be ruled by the one political party and the state may be ruled by the other political party. So what was happening that whenever when the new government come into power in the center, then what they are doing that if any other political party which is ruling in some other state where the political party which was in power in the center was not having the significant presence, so what they were doing that they were simply asking the governor either to resign, or they have gone to the extent of the sacking of the governors, and in their place they have appointed their own nominee as the representative of the center in that particular state, and it has created a lot of controversy with respect to the system of the appointment of the governor, because what is prescribed that if any person being appointed as a governor, then he shall hold the office for the durations of the 5 years, and this 10 years of the 5 year is subject to the exercise of pleasures by the president. So if the president has every power to withdraw his pleasures any point of time, but it is something what was happening that whenever the new government come into power in the center, then they invariably dismiss the governor which was being appointed by the previous government, and this practice became very prominent when the BP Singh government came into power in the center in 1989. Then they dismissed all the governor which was appointed by the previous Congress government, and after the fall of the BP Singh government and when the Chandrasekhar came into power, then he also followed the same practice, and when the PB Narasimha Rao became the prime minister, then he also adopted the same tactics of the dismissing all the governor which was appointed by the BP Singh as well the Chandrasekhar government, because when the PB Narasimha Rao came into power, then the Communist Party, which was a very important constituents of the government, then it becomes very vocal, and they start criticizing the functioning of the certain governor, certain decision which was taken the governor regarding the appointment of the regarding the inviting the persons to become the chief ministers. Then on the instance of the Communist Party, here the Narasimha Rao also decided to replace all the previous governor by the Congress nominee. So this practice, it has created a lot of apprehensions, and this practice was also being followed subsequently by the UPA 1 and UPA 2, and recently also when the new government came into the center, they have also continued with this conventions of the replacing the governor which was appointed by the previous government. So with respect to this, as far the if you see the Sarkaria Commission recommendations with respect to appointment governor, Sarkaria Commission has given the detailed guidelines as to what the practice has to be followed with respect to the appointment governor. So what the Sarkaria Commission has recommended that before appointment of person as a governor, here the state chief minister has to be consulted, and because the convention which has grown with respect to this matter and the practice which was being followed by the central government, where they are simply removing the governor on the basis that he is not he do not belongs to the same political party. So here some of the state has raised the concerns, and they have demanded that instead of the consultations, there has to be concurrence with the chief minister, and it is only after the concurrence with the chief minister the persons to be appointed as the governor of that particular state. But this demand of the state is not being accepted by the central government, and we still follow the practice of appointment of governor on the advice of the council minister headed by the prime ministers. And here if you see the detailed recommendation which was given by the Sarkaria Commission as to what the norms which has to be followed with respect to appointment governance concerns, if you see that the first recommendation was that the state must be consulted before the appointment of persons to the office of the governor, and state is insisting that instead of mere consultations, here there has to be concurrence by the state government before appointing a person as the governor. But this is not being accepted, and still we are following the practice of the consultations, and in name of consultation, what is happening in reality that here the respective state government is merely being informed that this particular person is going to be appointed as a governor of that particular state. And the second recommendation was that the governor should not belong to the same state, and this practice has been followed since the inception of the constitutions, and the governor which is appointed, invariably he has to be from some other state. And the other recommendation was that he should be eminent figure in any walk of life. So here before appointing a person to this August House, their preeminence, their integrity, their performance in the social, political or the educational field has to be considered, and it is a person of eminence has to be given chance to become the head of the state as the governor. And other recommendation was he should have detached himself from the local politics of the state. We have the instance where when the governor of the Himachal Pradesh was being sacked by the president because his son was fighting election and he was actively canvassing for the elections of his son. So we have these kind of instances where the governor is supposed to be impartial and he is supposed to be the constitutional head of the state, but here we have the instances where they have acted in the partisan matter and they will get involved himself with the local politics, and if the state is being ruled by some other political party, then that case he is giving some kind of the shelter to the political party to which he belongs. This is something which is not desirable under the constitutional setup, because he is expected to perform his duty as per the constitutional mandate. And the other recommendation was he should not have been engaged in local politics in the recent past. But if you see the practice which is being followed, that here the office of the governor has become the place where if any persons if they could not get elected to the parliamentary station, then it has become the place of habitations of the such defeated politicians or the persons who has almost reached to the age of retirement, though in politics there is no age of retirements. And so other recommendation was that he should not be politician of the ruling party at the center, and if the state to which he is being appointed is ruled by some other state, some other political party. But this practice is not being followed by any of the previous government, and invariably except in certain cases where the bureaucrats or the person of eminence has been given the charge of the governor, invariably what is happening in today's context is that here the governor is being is the man of that particular political party which are ruling in the center. Apart from this, the Sarkari Commission has also recommended that the persons of the minority group should continue to be given chance to be appointed as the governor, and apart from this, the system of the fortnightly sending of the report by the governor to the president should continue, because under the constitutional scheme, whatever the decisions which has been taken by the chief ministers or the existing law and order situation of that state, it has to be communicated to the president fortnightly by the governor, and in this fashion the governor acts as a very important channels of the communications between the center as well as the state government. And apart from this, if the governor is also having the very important power with respect to the reserving of any bill for the assent of the president, because if any bill has been passed by the state legislatures and if the governor is having any reservation with respect to such bill, then instead of giving assent to the such bill, they can simply reserve the bill for the assent of the president, and on such bill the president is not bound to give assent. So it can be reserved for any point of time, or it can be returned back to the state legislature for the assent. And here with respect to this matter, some of the political party has expressed the apprehension that here the governor is reserving the bill not on the merit but purely on the basis of the political motives. But this is not a true proposition, because we have the certain instances where it was very pertinent for the governor to reserve the bill, like the resettlement bill which was passed by the State Assembly of the J&K, and it was being reserved by the governor for the assent of the president, and the apprehension was being expressed in certain corner that if such bill will be passed, then it is something which will create a grave threat for the India's safety and security. So such bill was being reserved, and if any financial matter also, or the conversion bill which was being reserved by the governor for the assent of the president. So these are the kind of the power which has been given to the president, has been given to the governor with respect to the reserving the certain bill for the consideration by the president. So before that, first I will take you as to what are how the governor is being. So I have just given you the brief idea as to how the governor is being appointed. So now I'm coming to what are the positions of the governor, what are the constitutional scheme regarding the power of the governor. So as far the governor is concerned, so Article 153 says the office of the governor. So each state shall have the governor. However, the one persons can be appointed governor for one or more state. And if you see the provisions like the Article 154 of the Constitution say that the executive power of the state is vested in the governor, and he shall exercise his executive power either directly or through the officers subordinate to him. And as far the appointment of the governor is concerned, here the Article 155 provides the governor state shall be appointed by the President of India, and he has to be nominee of the central government. So, and here the with respect to this issue was also being considered by the Supreme Court in Hargobind versus Raghukul case in way back in the year 1979, where the Supreme Court stated that the office of the governor state is not an employment under the government of India or the government of state, so it does not come within the provisions of clause D to Article 319 of the Constitution. So, therefore, a member of state public service commissions can also be appointed as governor. So, as far the office of the governor is concerned, it is the independent office, it is the independent constitutional office, and it is not subordinate to the central or state government. As far the qualification of the persons to be appointed as the governor is concerned, here Article 157 prescribes the qualifications for the persons to be appointed as the governor, and says the person eligible to appoint as governor, he must be a citizen of India, and the second requirement that he must be completed the age of 35 years. Apart from this, we are not having any other educational or other qualifications for the persons to appoint a governor, and it is only the Sarkaria Commission which has recommended that only the persons of eminence has to be appointed as the appointed for the post of governor. As far the conditions of the governor office concerns, here it is being provided under Article 158 of the Constitution, and the first condition that the governor must not be member of either House of Parliament or House of Legislature of any state, but if any such member is appointed as the governor, then it will be deemed that he have vacated his seat in that house on the date in which he enter upon his office as the governor. So, there is no such constitutional provisions regarding the appointment of the elected member of parliament or state legislatures to the office of the governor, but once he is appointed governor, so he will deemed to have vacated his elected office the day on which he entered into the office of the governor. The other essential conditions for governor office is that he should not hold any office of profit, and this provision also applicable with respect to president, and the basic objective of this provision is that there should not be any conflict between interest and duty between the governor and his other constitutional obligations. Apart from this, it is also been prescribed that the governor is entitled to such emolument, allowance and privilege as may be determined by the parliament by law. So, definitely this provision also ensures that he is the constitutional head of the state, and he is though he is being appointed by the central government and political connotation, he is termed as the representative of the ruling party at the center, but as far the emoluments, allowance and the privilege of the governor is concerned, it is something which is regulated by the parliament. So, this is something which clearly shows that once after being appointment, he is supposed to perform in the impartial matter and as per the spirit of the provisions of the law as per the constitutional scheme. And if you see the kind of the salary which is being given to the governor, here the governor's emolument, allowance and privilege amendment act 2008 has increased the salary of the governor from 36,000 to 1,10,000, and apart from this he is also entitled to free use of the official residence, and his salary allowance cannot be diminished or reduced during the term of the office, and this provision has been incorporated in the Constitution to somehow ensure the sanctity of this august office. Apart from this, before entering office under Article 159, here the governor is required to take the oath and under this here he has to take an oath of affirmation before the Chief Justice of the High Court, and if the Chief Justice of High Court is absent, then that case the senior most judge of the High Court will give the oath, will administer the oath or affirmations to the governor, and he is required to take the oath to preserve, protect and defend the constitutions and law, and to devote himself to the service and well-being of the people of that particular state. As far the tenures and removal is concerned, definitely here the president, governor, once appointed by the president, he is entitled to remain the office for a period of 5 years. He may be given the second terms, but here this tenures of 5 years is subject to exercise of pleasures by the president. So if the president has decided, then he may continue. If the president has decided to withdraw his pleasures, then that case governor has to be resigned, or he has to be removed, and in their place some other governor may be appointed. So here this tenure of 5 years is also subject to condition that if the governor himself wants, then he can also resign from his office by writing to the president. So the clause 3 of the article 156 provide that here the president, the exercise of pleasure by the president is subject to the provisions of the clause 1 to article 156, and here the president pleasure is concerned, it is unjusticiable, it cannot be examined by the court, and it is purely depend upon the satisfaction of the president, which he is supposed to exercise on the advice of the council minister headed by the prime ministers. Apart from this, under the Indian constitutional scheme, the governor is also being given the same kind of immunity as is being enjoyed by the president under the article 361 of the constitution. And if you see the provisions of the article 361, then the governor is not answerable to any court for the performance of the power and duty of his office, and no criminal proceedings can be instituted or continue as long as he hold the office of the governor. But as far the civil suit is concerned, the same kind of immunity is not being enjoyed by the governor, and in that case, if any person is having any civil claim against the governor, or he wanted to bring any civil suit, then that case he has to give the 2-month notice in advance, and in that notice he has to detail the reasons on which he wished to bring a civil suit against the governor. So this the procedural formality of the giving 2-month advance notice and detailing the cause has to be followed by any person who wanted to bring any civil suit against the governor. As far the position of governor is concerned, he cannot court is not having power to issue any arrest warrant or order for the imprisonments of the governor while they are serving to the office of the governor. After discussing this, now I am coming to the power and functions of the governor. So as far the power and functions of the governor is concerned, definitely he is not having the same kind of power as is being exercised by the president, but in certain matter here the governor is having the power which is not available to the president. So as far the first thing which you have to keep in mind with respect to the executive power, the power of the governor concerns, here as far the governor is concerned, he is not having any diplomatic, military or emergency power, but the certain discretionary power has been given which is not being enjoyed by the president. So as far the executive power of the president is concerned, under article 154 it is being provided that the executive power of the state is vested in the governor, and it is to be exercised by him directly or through the officers subordinate to him. And if you see the provisions like the article 162, it says that the executive power of the state is vested and it extends in the matters with respect to which the legislature of the state is having the power to make a law. So as far the executive power is concerned, with respect to all the matter in which the state legislature will have the power to make a law, with respect to that matters, here the executive power of the governor shall extend. So as far this power is concerned, here this power is subject to limitations which is provided under article 258 clause 2 of the constitutions, and under that limitation which is being prescribed that the Union Parliament may authorize the state in relations to the matter in which the state legislature has no power to make a law. So with respect to any matter in which the state legislature is not having power to make a law, and if any such matter is being given to the state government by the Union Parliament, then with respect to that also the executive power of the governor shall extend. So however, as far the article 162 is concerned, here the article 162 does not define what is the executive power and what activity will legitimately comes within its scope. So ordinarily it connotes the residual of the government power that remains after the legislative or judicial power has been taken out. So as as far the executive functions of the governor is concerned, or the executive functions of the state chief minister is concerned, it comprises of the determinations of the policy as well as carrying out its executions. So thus is include the initiation of legislations, the maintenance of the law and order, the protections of the socio-economic welfare of the peoples, the directions to the policy of the state of the particular state, as well as the carrying out the general supervisions as well as the administrations of the state. So it is for the state chief minister who has the power to decide as to what kind of the executive policy they will follow, and he will also have the power to appoint all the officers to facilitate him to carrying out the executive functions. And with respect to that, the governor is merely required to act on the advice of the council of ministers headed by the chief minister. With respect to the executive power of the governor is concerned, this issue was considered by the Supreme Court in Shamsher Singh versus State of Punjab case back in year 1974, where the Supreme Court stated that the president and the governor are merely the constitutional head of the state, and they exercise the power and functions with the aid and advice of the council of ministers. And court further stated that where the constitutions require the satisfaction of the president or the governor, then it may not be his personal satisfactions, but it is the satisfactions of the council of ministers headed by the chief minister, except where the governor is required by the constitution to exercise his function as a discretionary power. So as far the discretionary power of the governor is concerned, we have the specific reference in the constitutions under which the governor is supposed to exercise discretionary power, and it is provided that with respect to it has been given to the governor of the Bihar, Odisha and Madhya Pradesh, where they are having the special responsibility to see that the ministers is appointed for the welfare of the tribal people. And in Assam also, the governor is given the special power regarding the administration of the tribal area as provided in the 6th schedule of the constitution. So here the Bihar, Odisha, Madhya Pradesh, Jharkhand as well the Assam, here the constitution has specifically empowered the governor some sort of discretionary power with respect to the ensuring the welfare of the tribal people as well the administration in the tribal areas. As far the further power governor is concerned, here he is having the power to appoint the chief ministers and on his advice the other ministers. So as far the appointment of chief minister is concerned, this is also becomes a very controversial issue with respect to the emergence of the multi-party democracy, where no single party is enjoying the complete majority, and that case the dilemma crop up before the governor as to who is to be invited to become the chief ministers. As far as these propositions and the convention which had developed with respect to this matter is concerned, here after the elections, if any political party enjoy the complete majority or the comfortable majority in the legislative assembly, then that case the elected leaders of that political party has to be invited by the governor to become the chief ministers. This is the first and the simple thing. But if the no political party are enjoying the comfortable majority, then that case who is to be invited? With respect to that, the governor, in certain case the governor has adopted the practice of inviting the single largest political party to form the government, and they are being given the time to prove their majority on the floor of the house. And some of the case here they have tried to prove the majority by adopting the tactics of the horse trading. On some of the case after the formation of the government, some other political party has decided to extend both inside or outside support. The other alternative before the governor regarding the inviting the persons to become chief minister is concerned, if the no political party has enjoying the comfortable majority in the assembly, then that case if any pre-elections or post-election alliance has emerged, and if that person is taking claim to form the government, then that case it is mandated for the governor to invite such persons to become the governor of become the chief minister of the state. But here what is happening that with respect to the inviting persons to become the chief minister, here in certain cases it is being alleged by the certain political party that here the governor is being dictated or guided by the advice which was being given by the central government, and he is inviting the persons to become chief ministers not on the basis of the arithmetic equations, but he is being invited on the basis of the affiliations, or in some cases he are being given the, in some case he is being given the 2-month time to prove his majority. Then in meantime here the person, the agreed political party approached the Supreme Court, and the Supreme Court has reduced this period to the shortest possible period, and they have asked the chief ministers to prove his majority on the floor of the state assembly. Apart from this, the governor and the one more things regarding the appointment governor is concerned, this issue was also being considered in details by the Supreme Court in the B.R. Kapoor versus State of Tamil Nadu case. Here this case pertains to the J. Jayalalitha, when in the previous time when she was being suffering from disqualifications to be elected the members of the state legislative assembly, when the AIADMK got the comfortable majority in the state legislative assembly, then that case Jayalalitha was being elected the leaders of legislative assembly, and she was being invited by the governor to become the chief ministers. But as per the constitutional scheme, she was not qualified to be elected as members, because what is being prescribed that if any person who is not a member of state legislatures can also be appointed, provided within 6 months he has to get himself elected to the assembly, or where there is a two house, then he has to get elected to the state legislatures or state legislative councils. But in that case, since she was suffering from disqualification for a period of 6 years by the order of election commission, so she was not entitled to contest the election. So this issue was challenged before the Supreme Court, whether this provision has to be also observed in such cases where the person is not being qualified to be appointed as a members of state legislative assembly or state legislative councils. Then that case, here the Supreme Court stated that in such case such persons cannot be given chance to become the chief minister, because it will amount to the fraud with the constitution, because here this provisions of the 6 month is only prescribed for those persons who are qualified in all respect, but that point of time he is not a elected members of that particular state legislative assembly. I will take up the detailed aspect of the this Kapoor case in my next lectures, where I will give you what the guidelines which was given by the Supreme Court regarding the appointment of persons as chief ministers, and I will also try to take up all the controversy which is surrounding regarding the various decisions which was being taken by the governor from time to time.
With this note, thank you sir, thank you so very much. Dear friends, if you have any queries regarding this particular lecture, you can mail us at info.cec@nic.in. If you have any questions, definitely we would love to solve your questions. We would love to give answers to your questions the next time when Dr. Kumar visits our studio. And if you want to access this particular lecture, you can access it with the help of the YouTube. With this note, thank you sir, thank you once again.
Thank you listeners. Thank you, Deepika.